For any libertarian, the Second Amendment is basically a god. It does, after all, completely enable their neo-Confederatism, which of course was discussed on the last episode of this show. But we have a unique problem in this country that other countries don't have, and that is the Second Amendment. This has been used in recent years to expand gun rights, while laws that seek to curb gun ownership and make it more restrictive are constantly shot down. Pun definitely not intended. So what we have is a population that is completely on edge, loaded up with guns, and unable to pass laws to reasonably restrict gun ownership because of the Second Amendment to the United States Constitution. So, let me get my dab on so I can be in the properly half-baked state of mind, and then we'll get this show on the road. Okay. And we're back. When it comes to the Constitution, libertarians love to think of themselves as experts, almost as if they've all gone to law school and studied constitutional law for like 10 years. You know, you talk to most libertarians and they will express to have a profound knowledge of the Constitution and, you know, all of the founding father documents, the Federalist Papers, the, you know, fucking journal entries from Thomas Jefferson, I don't know, whatever the hell. But really, most importantly, they should have one of these pocket Constitution / Declaration of Independence books. This happens to be published by the Cato Institute, which means, yes, I purchased it in support of the Cato Institute. I told you, I used to be an actual libertarian. So, I mean, not only do I have one of these, but it's like, it's notated. Like it's marked all the way through. I took notes. I'm an active reader. So, you know, I took the shit seriously. I thought that everybody took the shit seriously. But then I see, you know, completely off the wall things, and it shows me why I'm doing this. But before we get into all that, I completely forgot. Let's do the basic house cleaning first, which is, you know, if you haven't clicked on the like button, go ahead and do that right now. Just go ahead and give it a little tappity tap. And that will, you know, help me out a whole lot. Go ahead and subscribe to the channel if you enjoy this content and want to see more of it. And make that bell notification ring if you want to get notified every time I upload a new video, which is not very often, so you won't get too many notifications. So, you know, it's kind of a good thing, right? We all get enough notifications as it is, I think. So, and then of course the best action all happens on Twitter. That is at DrinkYourOJ is my handle right there. So if you want to follow me on Twitter, I tweet about politics, but I also tweet about other things that aren't politics. And, you know, I try to keep it kind of general. So, yeah. That's our house cleaning. And let's get back to discussing how libertarians are not as well versed on the Constitution as they like to think they are. So we've got this character here saying simply that our rights are not up to a majority vote. And that's just a basically incorrect statement. You know, the entire amendment process, Article 5 of the U.S. Constitution, exists specifically to make changes to the Constitution. Now, that may include adding rights, such as the first 10 amendments, especially the First Amendment, removing them, such as the 18th Amendment, or modifying them, such as the 21st Amendment, which removed the 18th Amendment. So, you know, we can make all the changes that we want to the Constitution. And, you know, an example of this is right here in my pocket Constitution itself, talking about, you know, the 3/5 compromise and basically explaining how, you know, representatives and taxes are going to be figured out according to non-white people being counted as 3/5 of a person, which is a fucked up notion and something that, you know, needed to be changed. And so we as a nation recognized, hey, this is fucked up. Let's change this. And we went ahead and ratified the 14th Amendment, which took care of that in Section 2, as it notes right there in the footnote. So, you know, we can make changes to the Constitution all the time. It's not easy by any means, but it can be done. So to say that our rights are not up to a majority vote is simply factually incorrect. They're always up for a vote. You get enough of a majority and anything in the Constitution can be changed. So I was on another website and I see this character calling himself Gene Simmons saying that any right that requires federal funding, taxation, is suspect. It is not allowable for the federal government to take money from any U.S. citizen to pay for someone else's claim to a right. Of all the 10 amendments to the U.S. Constitution, the 10th carries the most weight because it constrains the federal government. Now, I have a lot of problems with that statement, but the most obvious of which is the fact that it's clearly from a libertarian, right? Because they go right to taxation is theft, basically, is what he's saying here. And so it's not accurate to say that the federal government can't take money from any U.S. citizen, because right in the U.S. Constitution, in Article 1, Section 8, in the very first clause, it says the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. So, if this person's comment were true, USPS would not have received $10 billion in federal funding as part of the CARES Act in response to the COVID pandemic. Similarly, the Navy, the Army, and the ability for Washington, D.C. to maintain any of its buildings or infrastructure would be unconstitutional, as all of those things are paid for by federal tax dollars. So, we just have a few examples here of libertarians not quite grasping the Constitution quite as well as I think they might think they do. Now, another right that is obviously up for a vote and very much in the news right now is a woman's right to control her own medical treatment. And, libertarians who are ever supportive of states' rights should be outraged at the concept of any kind of federal abortion ban. The fact that, they may or may not be pro-life is irrelevant, because their ideology would state that there shouldn't be any federal control over a decision like that. So I have to give credit to Rand Paul, as much as I think he is totally incorrect and backwards in his decisions to not fund Planned Parenthood, which leads to fewer abortions because it provides, better access to contraceptives. And so fewer unwanted pregnancies in general means fewer abortions. So rather than restrict the number of abortions that people are allowed to get, if we simply reduce the number of unwanted pregnancies, then that accomplishes the same goal. I don't agree with any of his decisions regarding not funding Planned Parenthood, but I do have to give him credit for saying that, Lindsey Graham's bill is basically something that doesn't make sense. I think that this is a decision that needs to be decided state by state. I don't think any federal legislation that either codifies abortion or outlaws abortion is going to pass at this point. So he's also being a Republican a little bit there by saying that this is not going to pass at this point, because, of course, the Republicans' game right now is to make sure that everybody thinks nothing really has happened with regards to abortion things really changed because they know how horribly unpopular it is, and they don't want to get their asses handed to them in the midterms. So they want people to forget that they just had this major legislative victory that they've been fighting for, or not legislative, but, judicial victory that they've been fighting for, for half a century almost, or maybe longer. I don't know exactly. But now they're trying to cover it up instead of spiking the football, because they know that Americans in general aren't in favor of it. And so they want people not to be thinking about it when they go to the ballot box in November. So anyway, back to the Second Amendment specifically. Let's take a look at the language that is used. It says here, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Now, we have commas after militia, state, and arms, which means this is technically a run-on sentence. I think. I don't know. I'm not that great at English, but it's definitely not like a correct sentence, because it refers to multiple different subjects. At the end, where it says it shall not be infringed. Now, are you saying that a well-regulated militia shall not be infringed, or the right of the people to keep and bear arms shall not be infringed? And either way, a well-regulated militia being necessary to the security of a free state is a qualifier. The right of the people to keep and bear arms shall not be infringed. So, it's not as clear-cut right as, say, freedom of speech. Let's take a look back at a few other Supreme Court cases, or at a few Supreme Court cases, and get some background on kind of the history of how the Second Amendment has been handled in the courts. So, in 1939, there was a case of the United States versus Miller, which had to do with the National Firearms Act. And it was decided that the NFA was not unconstitutional as an invasion of the reserved powers of the states, and that it did not violate the Second Amendment. So that basically established that the federal government could control guns or firearms to an extent. And then in 2008, there was D.C. versus Heller, which struck down a Washington, D.C. handgun ban. And at that point, the Second Amendment guarantees an individual's right to possess a firearm unconnected with service in a militia. However, this right is not selectively incorporated. So, in other words, these amendments apply specifically to the federal government, not to each of the 50 states. So, only at the level of the federal government are you protected, for this right to possess a firearm unconnected with service in a militia, as of D.C. versus Heller. Now, in 2010 comes McDonald versus Chicago. And that one decides that the Second Amendment right to keep and bear arms for self-defense in one's home is fully applicable to the states through the 14th Amendment. So it is selectively incorporated. There was a Chicago handgun ban enacted in 1982, which made registrations so cumbersome that it essentially prevented most Chicago citizens from owning a handgun. Residents claimed that this regulation violated their 14th Amendment right with respect to the Second Amendment. So there was a 5-4 decision against the ban. SCOTUS ruled that the Second Amendment for self-defense is applicable under the 14th Amendment. So that means the Second Amendment is being selectively incorporated to apply to the states as well as to the federal government. However, justices did state that reasonable gun restrictions should remain. So I want to read an excerpt from an article published in Salon by Sonia West. Take, for example, our freedom of speech. It is one of the most clearly stated and robustly protected rights in the Constitution. Yet it is also subject to numerous restrictions. Our speech might not be protected if it falsely damages someone's reputation, aids and abets a crime, contains a threat of violence, reveals a trade or military secret, harasses, plagiarizes, inflicts severe emotional distress, is deemed to be obscene, incites violence, or leaks classified information, just to name a few. The United States Supreme Court further allows restrictions on when, where, and how we can express ourselves, even when the message itself is protected. In some cases, we control who may speak, such as limitations we may constitutionally impose on the speech of students, prisoners, and government employees. When determining what regulations on speech are acceptable, the Supreme Court carefully weighs the significant value of protecting the freedom of expression against the countervailing public interests. Thus, you certainly have a right to protest, but not in a public park without a permit. You have a right to exclaim your beliefs, but not with a sound truck at night in a residential neighborhood. You have a right to express yourself through art, but not with a can of spray paint on someone else's car. Child pornography is indisputably a type of speech, yet the Supreme Court gives it no constitutional protection, zero, because the court believes that the harm it inflicts on the abused children far outweighs any expressive value. The same is true for our freedoms to exercise our religions. The court has held, in an opinion authored by Justice Antonin Scalia, that as long as government regulation applies to everyone equally and does not target a particular religious group, many general laws that infringe on religious practices are nonetheless constitutional. Thus, if your religion involves the use of a banned hallucinogen like peyote, as was the situation in the Supreme Court case involving members of the Native American Church, your constitutionally protected right to freely exercise your religious beliefs takes a back seat to the state's interest in uniform drug laws. And I could go on, so I will. We have the constitutionally protected right to peaceably assemble, but not to block traffic. We are protected from unreasonable and unwarranted searches, unless there's a probable cause, exigent circumstances, or a hot pursuit. If charged with a crime, we have the right to a speedy trial, but not if the prosecution is hunting down witnesses, and also a public one, but not if you want your trial televised. We also have the right to a trial by jury, unless the crime carries sentences of 6 months or less. In the Second Amendment, of course, there is no exception. In the 2008 case of District of Columbia versus Heller, the Supreme Court told us that we have a constitutional right to possess firearms for self-defense, at least within our homes. But the opinion never suggested that this right was all unconditional or immune from any regulation. In fact, Justice Scalia, writing for the majority, said just the opposite. In Heller, he specifically said that the right secured by the Second Amendment is not unlimited. Protecting the right to keep and bear arms is not the same as forbidding all regulations on that right. We can protect that right and still require background checks, permits, and training. We can still regulate when, where, and what kinds of guns are allowed. In some cases, we can regulate who can obtain guns, imposing restrictions on, for instance, felons, the mentally ill, and known terrorists. We can ban firearms, such as military-style assault weapons that, like child pornography, plainly cause far more harm than they add in value. We can require those who are negligent with their weapons, as we do those who are negligent with their words in defamation cases, to be held liable for the harm they inflict on others. We can do all of these things. We just don't. There might be policy reasons to debate the pros and cons of specific regulations, but there's no reason to assume that there is a constitutional problem. And you don't need to take my word for it. Let's listen again. Let's take another listen to Justice Scalia in Heller, shall we? The Second Amendment, he stated, does not protect the rights of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of the citizens to protect for any purpose. And you don't need to take my word for it. Let's take another listen to Justice Scalia in Heller, shall we? The Second Amendment, he stated, does not protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of citizens to speak for any purpose. He further noted that nothing in the court's decision should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing the conditions and qualifications on the commercial sale of arms. But, people argue, the text of the Second Amendment says, shall not be infringed. Shall not be infringed. They might even say it to you in all capital letters. Now, the framers used the words shall a lot, but it turns out that many of the constitutional rights they wrote about in unqualified terms are in fact qualified. Some amendments, for example, tell us that the government shall make no law abridging, or shall not deprive any person of, or shall not make or enforce any law which shall abridge certain rights. Others declare that a right shall not be violated or shall be preserved, and yet many of those rights have been subject to restrictions over the years. Considering that the framers prefaced the Second Amendment with the observation that a well-regulated militia being necessary to the security of a free state, its language shall not be infringed, notwithstanding, is arguably less absolutist than many other constitutional provisions that did not come with a qualifier. Our constitutional rights are not an all-for-nothing deal. We can uphold the Second Amendment and still pass reasonable regulations that further protect the public's interest and safety. So don't feel you need to choose between protecting our Second Amendment rights and supporting sensible gun regulations. Why should you? The Constitution doesn't. So what are some possible solutions without an amendment? Because amending the Constitution is damn near impossible by design. And then add in all sorts of roadblocks that the founders never intended, like the filibuster, and you've basically got a government that is incapable of evolving, which is what we have right now. So clearly we have a problem that has to be solved. We have more firearm suicides than any other country in the world. So if we take a look at your murders, first of all, you can see that for every 100,000 residents, the United States far outweighs many other developed countries when it comes to murders, gun murders specifically. We have more than Italy, Finland, Canada, Sweden, Germany, Australia, France, the UK. And then Japan and Iceland have virtually statistically eliminated gun murders from their society altogether. And then you look at our murder and suicide rates. The United States has the highest firearm suicide rate of any country. So people buy guns for protection, but the fact of the matter is that having a gun in your home makes it more likely that you will accidentally shoot someone that you care about, or someone that you care about will use the gun to inflict harm on themselves, much more than you're ever going to use the gun against an intruder. If we look at just specifically comparing the US to Iceland, if we look at the number of guns per 100 residents, the US has about 3 times as many as Iceland. We're, of course, number 1 in the world in that statistic. But Iceland, that doesn't mean they don't have any guns. 30.3 out of every 100 residents has a gun. So that's about a third of everyone in the country. Compared to almost 90% of the United States. It's not actually that 90% of the United States has guns because, it's concentrated in certain people have a lot of guns and certain people don't have any. But going down the list, looking at the homicide rate, the U.S. is 7 times higher than Iceland. The murder rate is, per million people is 13 times higher than Iceland. The rapes per million people is 12% more than Iceland. The robberies is 12 times more than Iceland. Now, interestingly, Iceland does have more burglaries than the United States. But a burglary is, compared to theft or robbery, it is the lowest bar of crime, basically. A burglary is just that you enter a structure with the intent of committing a crime. Whether that crime is theft or some kind of violent act, whatever it is. If you enter a structure with the intention of committing a crime, that's burglary. So burglary usually goes along with another charge, such as theft or robbery. The difference between a theft and a robbery is that a theft involves somebody just taking something, whereas a robbery is a more violent, direct action. It involves you essentially, assaulting somebody to get the thing away from them. It is interesting to see that there's more burglaries. But, the point that I was trying to show is that the fact that people are less armed doesn't at all seem to have an impact on crime. In fact, they have far, far less crime than we do, even though they're less armed. So the idea that you need to be armed to protect yourself from these crimes is, just ridiculous. There are other ways of doing it. Clearly, other countries have figured that out. So what are some other solutions that we can look at in the short term? I think firearm trusts can't be used by people who would otherwise be barred from owning the weapons in question. We should require fingerprinting and vetting of everybody authorized by these trusts. Gun trusts help people by providing a framework to obey gun control regulations, thereby reducing the risks of handling restricted firearms. Like a regular trust, property in a gun trust is held by one party for the benefit of another. Therefore, a gun trust helps your loved ones inherit your firearms safely, lawfully, privately. Having a gun trust is especially important when dealing with certain firearms regulated by the NFA. Firearms that are regulated by the NFA are often referred to as Title II or Class III weapons. These types of weapons include silencers, suppressors, short-barreled rifles and shotguns, and machine guns, full automatic weapons. The background check requirements that the NRA and others have fought so bitterly against are really a good idea. 90% of Americans support universal background checks for gun purchases, according to PolitiFact. We should modify records keeping so that dealers can't destroy the 4473 forms that some do out of misguided political convictions. And when they go out of business, the ATF should collect all those forms. ATF Form 4473 is the form used when purchasing a firearm from a gun store. The form is filled out by a purchaser, and it includes information about both the purchaser and the firearms. Make each form and NICS check, NICS being the National Instant Crime Background Check System. Make each 4473 form and NICS check come with a unique identifier, not identifying the weapon or the recipient, but the specific transaction. And if the dealer can't show that he still has the form that goes with the transaction, then they lose their federal firearms license and they face legal consequences. You know, pharmacists are expected to do exactly this kind of chain of custody when it comes to drugs. So why shouldn't a gun dealer be expected to do the same with deadly weapons? Another thing is that a couple dozen dealers are responsible, according to both pro and anti-gun types, as well as legitimate academic researchers, for a disproportionate number of illegal sales, straw sales, out-of-state sales, sales without NICS checks, and sales of weapons which end up in criminal hands. We should not be defending them. We need to come down hard on them. This has been proposed a few times, and every time the right to keep and bear arms lobbyists have screamed and protected them. Self-defense with castle doctrine and no duty to retreat when it's not safe to do so is something that I think is okay. You know, I'm a proponent of that in theory. The current crop of stand your ground laws has been used as kill all the witnesses laws. They're used by criminal gangs to skate after gunfights with other gangs on the grounds that the combatants had a fight to be in the public place is a sign that laws are really horrible pieces of legislation. And, you know, I shouldn't have to mention Kyle Rittenhouse. He got off on a different law that was bad, but the fact remains, we need to tighten up our laws that already are on the books when it comes to gun control. That's completely within our power. If we had written the laws better, then these people would have been able to be prosecuted. We need to have a single nationwide shall issue standard for CCW with nationwide reciprocity. And we should require significant, but not prohibitive and not homeopathic, training and competence testing for that license. That's common sense. If your sight is so impaired that you can't drive a car with corrective lenses, then it's not safe for you to carry firearms in public. So, states that allow silly things like that kind of thing needs to stop. We need to refund and reopen the courts that were supposed to allow felons who had served their time to get their civil rights back. And in return, we should institute a policy for prosecutors to stop bargaining away felon in possession charges right off the bat. Something that's more complicated and requires more political will is to drastically reduce the use of paramilitary training and equipment for civilian police. Stop using them as a market for what would otherwise be military contracts. This is not a new problem, and curbing it would reduce the arms race between criminals and police. And there's a study called The Ethics of Restrictive Licensing for Handguns, comparing the United States and Canadian approaches to handgun regulation. And I'm going to link it in the description. But the authors come to the conclusion that the United States and Canada regulate firearms, particularly handguns, quite differently, with only a few state and local exceptions. The U.S. approach emphasizes the ability of most individuals to purchase, possess, and carry handguns. By comparison, Canada has a form of restrictive licensing for handguns that places a premium on community safety. The authors first review the potential individual and community-level harms and benefits associated with those offering firearm policies. Using this information, they explore the ethical dimensions of the U.S. and Canadian approaches through three major themes of autonomy, prevention of harms, and social justice. The authors conclude that the Canadian approach is consistent with respect for the autonomy of persons, fosters the prevention of harms, and more appropriately furthers social justice. And when it's not safe to shoot, it's not safe to shoot. Period. Recent deadly wildfires, have been caused by people shooting in areas with dry vegetation. The screams when officials suggested a moratorium on outdoor recreational shooting were ridiculous and loud, but your right to shoot for fun or practice does not extend to setting fires that kill people and cause millions of dollars worth of damage, period. And another reasonable restriction is that requiring less environmentally harmful ammunition for hunting waterfowl is not a commie plot to take your guns. It won't kill anyone to use bismuth, steel, copper, or some other alloy for those few dozen shots when you're actually out on the water. That lead does real, measurable harm. So those are just a few things that we can do without even getting into amending the Constitution. So, one major problem in our society, in my estimation, is the glorification of violence through media. Films, TV shows, video games, music, even the news. If it bleeds, it leads, as they say. That makes guns cool and fashionable, and everyone loves a new toy to accessorize. An AR-15 is essentially just like an Arduino kit that is much more effective at mowing people down. Or for the less geeky among us, Barbie and Ken's accessorizable killing machine. Libertarians don't see this as a problem whatsoever, despite the fact that there is a mass shooting in the United States virtually every single day. this is the kind of world that they kind of imagine we would have. There would be a system of, different private courts, and if I don't agree with your court, then whoever has bigger guns and more of them and can use them better will, blow the other one away, and that'll solve that. So, on that happy note, I think what we're going to do is I want to talk about some of these issues with regards to abortion and states' rights, and especially tied into maybe the impact on the midterms. So I think that's what we're going to go ahead and do in our next episode of Half-Baked Libertarian. So, again, make sure to go ahead and smash that like button, hit subscribe, and I will see you all on the flip side.